If everyone could take their seats, we're going to resume the presentations. Our next speaker is Michael Collins. Michael is a shareholder at Kinney & Lang, and he's going to be speaking about divided infringement after Akamai versus Limelight.
Good afternoon. This has been great, hasn't it? I've been really just blown away today by how nice the weather is. It's just been unbelievable. And the presentations have been very good as well. As Katie said, I will be talking today about divided infringement, which arises when you have multiple parties doing the infringing acts rather than a single party. And we'll be talking about divided infringement after the Federal Circuit's decision in Akamai v. Limelight. Now, I would wager that at least some of you, if not all of you today, have benefited from Akamai's technology. Has anybody heard of Akamai technology? One person? Limelight? Anybody heard of Limelight? A couple of you? Now, these are, that's fantastic. I had not heard of them. They are the companies that help make the internet go a lot faster. And so we're gonna talk about them a little bit today, just because I find it really interesting. And then after that, we'll talk about the Federal Circuit's decision in Akamai v. Limelight, which is significantly less interesting. So let's start in 1996, when the internet looked like this. Oh, that's not it. Like this. This is the New York Times from 1996. And I got this from an internet archival site. Maybe you guys have probably heard of it. It's a Wayback Machine. You can go and look at old internet pages, which is absolutely fascinating. Not right now, but after the presentation, go take a look at it. It's really interesting to see just how websites have changed in the last 15, 16 years. Now you look at this, you notice there's not a lot of content. There's not a lot of pictures, not a lot of video, certainly no advertisements. Here's another one. This is Pizza Hut's webpage back in 1996. Again, not a lot of content, no videos, not a lot of images. And there are a couple of reasons for this. First, modem speeds. Back in 1996, you had a 28.8 megabit modem. If you had a really fast one, it was 56.6. So on the client side, you just didn't have a lot of bandwidth available to download a lot of content. But you also had problems on the provider side. They were dealing with similar constraints in how much bandwidth they had. And so you ended up with pages that just didn't have much content on them. So this is a really basic diagram that I drew myself of how the internet works that will help illustrate the problem that Akamai was trying to solve. So we have this guy on the left. He's got his little laptop, because he had a laptop in 1996. And he wants to visit his favorite web page, which is uspto.gov. So he types that URL into the address bar, and that URL gets sent not directly to the USPTO server. That goes to a domain name server first. The domain name server takes that URL address and says, oh, this is the computer you're looking for, and it returns to him the IP address, which is going to be a 32-bit number. Now, you could type that 32-bit number directly into your URL address, but you'd have to remember that 32-bit number. So that's what the domain name server does, is it remembers all these IP addresses, and when you go to a website, it returns that. So now you have the IP address. Now you put that in, your computer now sends a request out to that address, which is received by the content provider site, which in this case is the USPTO government site. In response to that request, the government will return this HTML page, which your web browser interprets and displays in your screen. Now I've shown an HTML page on the right there. You can kind of see it there. And what I wanted to point out is in these web pages, and this one's from today, what they will have is not only the content that's going to be displayed, like the words and the text and how it's going to be displayed, but they'll also have these embedded objects. And so you see them there, you see these URLs where it says, HTTP. Now that's going to be like a picture or a video or something else that the web page is going to send, and when your web browser gets it, it's going to go and request that object. Now this is the limitation that these companies have is they don't have a lot of bandwidth either. And so the way it used to work is, if you have 1 or 2 users, 10 users, then that government server or whatever server can handle those requests. As that number grew to hundreds and then thousands and then hundreds of thousands, now those servers can't respond to all those requests, and they don't have the bandwidth to supply all of that content. So the solution initially was, we're just going to mirror these servers around the country. We're going to take, if we're Best Buy and we have 10,000 requests a year on our website, we're just going to have different servers located around the country, and they're all going to be identical. And when you request a Best Buy website, you're going to get routed to one of those. And the problem with this is you have to somehow keep these all synchronized together. You make a change on one, now you got to make a change on 99 others. And you got to figure out how to balance the loads across those so they're all getting equal treatment. So this is the problem that Akamai entered in 1995. And Akamai was founded by some researchers at MIT, which I just found out in the green room. One of our associates actually knew the professors at MIT. Doesn't she wish she'd made different decisions now? So Akamai still uses a plurality of servers, but what they do is rather than just mirroring that content in each server, what they're going to do is they're going to store just the embedded content in their servers. So if you're Best Buy, you're still going to have your server, and you're still going to have your web page, and you still have control over that. And then when a user types in bestbuy.com, they're going to get directed to your server, and they're going to get the web page from you. But now what they're going to do is they're going to modify those embedded objects we talked about. So remember all those embedded objects? Those are not going to point to Best Buy servers now. Now those are going to point to Akamai servers. And Akamai doesn't just have a few servers. They have hundreds of thousands of servers spread around the world. So now when you're downloading that content, Best Buy provides just the web page, and then all the content, all the videos and the pictures and whatnot, that's all getting uploaded by Akamai. That's why I say when people today probably took advantage of it. If you're on your phone, if you're looking things up, you were probably benefiting from Akamai's technology. By their own account, they handle about 30% of the web traffic on the internet. So these MIT guys, they come up with this great idea. They patent the heck out of it, and they form their company, Akamai, which is Greek for smart, clever, or wise, but apparently not humble. So here's Akamai's patent. And we're just going to walk through it briefly, and I'll translate the patentees to English for you. So they have a content delivery service comprising replicating a set of page objects across a wide area network of content servers managed by a domain other than a content provider domain. So these are all the objects, all these embedded objects. These are going to be stored on Akamai servers. That's what they're saying there. Second step, for a given page normally served from the content provider domain, tagging the embedded objects of the page so that requests for the page objects resolve to the domain instead of the content provider domain. So this is modifying those objects, going into whatever customer that they're working with, Best Buy's HTML page, and modifying those embedded objects so that they point to Akamai servers and not to Best Buy servers. Third step, responsive to a request for the given page received at the content provider domain, serving the given page from the content provider domain. I have no idea what that means. So this is getting the HTML page from Best Buy. You request the page, it's delivered to you from Best Buy. And then finally, serving at least one embedded object of the given page from a given content server in the domain instead of from the content provider domain. So this is, instead of Best Buy supplying the objects, now the objects are being supplied by Akamai. Now, enter Limelight. Limelight, for our purposes of our discussion today, I actually don't know how their product works, but for purposes of our discussion, Limelight does exactly the same thing. The only thing Limelight does not do, or does differently, is they don't modify the embedded objects themselves. What they do is they tell their customers how to do that. So, when we look at this, who thinks that Limelight is infringing this patent? Who thinks they're not infringing this patent? who wasn't listening at all. Well, my gut is that you look at it and you think, they're probably infringing this patent. They're doing all the steps, and they're telling their customer how to do the last step. So when you look at it, the gut reaction, at least that I had, was, yeah, Limelight's probably infringing this patent. And the jury would have agreed with me. The jury, when this was at district court, the jury said, yeah, this is patent infringement. And they awarded damages to Akamai. But the question we have is, under what theory of infringement? Infringement is defined in section 271. And so we're just going to walk through that and try to figure out under what theory of infringement Limelight is infringing these patents, because we all know that they are. The first is section 271A. And this is the one that everybody thinks of when they think of when they think of patent infringement. This is direct infringement. So 271A says, except as otherwise provided in this title, whoever without authority makes, uses, offers to sell, or sells any patented invention infringes the patent. Now, one thing to note about this is, over the years, the term whoever has been interpreted to require that a single actor perform all these steps or meet all these limitations. We're going to talk today mainly about method patents, because that's what's at issue in Akamai, and that's where this situation arises most frequently. So in the sense of an infringer having a method, they'd have to perform all the steps of that method. Well, if you look at it there, now who thinks that Limelight infringes that patent? I mean, they're clearly not doing one of the steps, right? So there's no direct infringement here. They have moved that step over to their customers. So there is no direct infringement. And that's what the district court said. After the jury returned a verdict of infringement, the district court overturned it in a JMOL motion and said, nope, there's no infringement here. Now, you could argue that there was an agency-like relationship. And Akamai did argue that. And they said, well, they were instructing their customers. They were telling their customers, how to modify those objects. And if their customers wanted this thing to work, they would have to modify those objects. But the court said, no, there was no agency relationship. They weren't directly controlling the actions of their customers. Their customers were free to modify those embedded objects or not. So we had no direct infringement under 271A. How about 271B? 271B is inducement to infringe. So inducement is you didn't perform the steps yourselves, but you induced, encouraged, helped another party perform all those steps. 271B says whoever actively induces infringement of a patent shall be liable as an infringer. Now, the Federal Circuit has addressed this issue just recently. In 2007, they decided a case, BMC Resources v. Payment Tech, where they said, and they based this on a long line of cases, that direct infringement under 271A is a predicate to finding induced infringement. All right? So based on that, does Limelight infringe? They don't, right? There was no direct infringement. We just talked about 271A, and we know there's no direct infringement here, so therefore there's no inducement to infringe. Now, the other thing to keep in mind with 271B, and we'll come back to it, is that it has there's extra kind of things you have to do to induce infringement. One of those being you have to have knowledge of the patent. But the big takeaway, at least this is all pre-Akamai. This is before we got into the Federal Circuit, is that no direct infringement because there's no single actor, therefore no finding of indirect or induced infringement. Well, this is absurd, clearly. It's actually better for Limelight to perform some of the infringing steps rather than perform none of them. So you see, from Limelight's perspective, if they perform none of the steps and they had their customers do all of them, now they could actually be held to infringe under a theory of inducement. By doing some of the infringing steps themselves, and in this case they did 3 of the infringing steps themselves, they've actually avoided infringement. So that is a very interesting result. It's a huge loophole, and in particular when you're talking about computer interactive type patents, which have really become prevalent in the last 20 years, this is a huge loophole. If you're looking at infringement, you say, well, we do all these steps, an easy workaround is say, hey, why don't you do one of these steps? You're our customer, you do one of these steps, we'll do the other three, and no infringement. And interestingly enough, this premise was so well settled that on the appeal, Akamai didn't even raise this. They were arguing for a theory of infringement under direct infringement with an agency-like relationship. Didn't even raise that this was, they raised it at trial, but they didn't really push it on appeal. And we see this in a lot of other issues as well. I mean, I was talking to Dave Fairburn earlier this week, and we were talking about the idea that the law doesn't really change. I mean, 271B, 271A, these words stay the same. And the facts is what really changed. I mean, you get these new technologies. We see that in the patentable subject matter cases where how is the court going to how are they going to handle these new technologies? Is a gene patentable? Is software patentable? And that's what we see here is, how do we deal with induced infringement in a situation where it's so easy with computers to just move a step to a different party? Okay, so the decision gets Akamai gets their jury verdict, which is overturned by JMOL. They appeal to the Federal Circuit. A 3-judge panel hears the decision, and they agree. They affirm the district court opinion. The Federal Circuit then agrees to rehear it en banc, and the decision gets decided last year. And they end up, again, the issue on appeal was more about direct infringement. They end up deciding it on a theory of inducement. And they actually overturn the decision we looked at, BMC v. Payment Tech. They overturn that decision, and they say, under a theory of inducement, it's not required that a single actor perform all of the steps. And the court notes the absurdity of that previous result. And they say, listen, that can't be the right answer. It can't be that you actually are in a better position by doing some of the steps yourself. So the case gets remanded, and providing that Limelight could be liable for induced infringement if Akamai can show that Limelight knew of Akamai's patent, that it performed all but one of the steps of the method claim in the patent, that it induced the content providers to perform the final step, and that the content providers, in fact, performed the final step. So the big takeaway from Akamai is that they get rid of this single actor rule. But now this was a sharply divided court. There was 2 dissents in the court. Oh, look at that. I forgot I had put these in. There. So there's the holding. Induced infringement does not require a single actor. And there's more. Remanded, providing that Limelight could be, all right. Moving on. Okay, so we have a dissent by Judge Newman. And this is not really a dissent at all. What Judge Newman said was that the court didn't go far enough. She essentially agreed that the single actor rule was absurd for inducement, but she thought that they should get rid of the single actor rule for direct infringement as well. The other dissent by Judges Lynn, Dyke, Prost, and O'Malley would have affirmed the single actor rule under BMC. All right, so to summarize quickly, direct infringement has essentially remained unchanged. It's still strict liability, which means that you don't have to have knowledge of the patent. If you perform the methods, whether or not you know if the patent even exists, you're still liable for infringement. Joint infringement is still available if an agency relationship can be shown between the parties. Indirect infringement has changed considerably. No longer requires direct infringement as a predicate, no single actor rule. Still requires knowledge of the patent and intent to infringe. No agency relationship required, but the inducer must cause, urge, encourage, or aid the infringing conduct. So I said the court was strongly divided. Petitions have been filed for cert. They should be out in the next few days from the Supreme Court to see if they're going to grant cert. In this case, I would think they probably will. Like I said, it's a strongly divided court. It's on an issue of statutory interpretation, and what does 271A mean? What does 271B mean? So I think this is probably a good candidate to be picked up by the Supreme Court. All right, winners post-Akamai. Certainly, if you are a patent holder, if you have a method claim that you are looking to enforce, this was a great decision for you. This makes it much easier for you to both bring a suit under a theory of inducement to infringe, makes it much easier for you to survive summary judgment. So this will make it much easier for method patent holders to enforce their patents. Particularly relevant to software patents today, where you're going to see a lot of the steps being bifurcated between multiple parties. Now, the losers after Akamai are going to be the companies. If you're a company that is performing some of these steps, maybe you've even looked at some of these patents and have avoided infringement by bifurcating your actions. You'll want to take a look at that again and see if you need a different theory. And it's going to create a lot of uncertainty. I've already talked to a couple of people that have asked about this, and it's going to create some uncertainty in whether you infringe. And before, it was pretty black and white. If somebody comes in your office and says, hey, I'm concerned about this method patent. I perform these steps, but so-and-so performs these other steps. What do you think? It's like, I don't even have to charge you 6 minutes for this. I know the answer. You don't have an infringement issue. Now it's going to be much murkier. All right, tips for practitioners. First tip, draft single actor claims. Now, I know I said at the beginning that when we talked about Akamai that they overruled the single actor requirement. You still want to draft single actor claims. If you take away nothing else, nothing else from today, take away that you want to have single actor claims. Whether you're drafting patent applications, whether you are reviewing patent applications, think about your claims and whether one person could infringe that claim. This is something that I learned as a clerk in my first year. It's something that I preach to anybody that I'm working with now is let's look at the claim and see, could a single entity perform all of these steps? I think the case that I wrote was, some device, and I think I included a power source in the device. So let's say it's a toaster, and I include in the claims a power source. Well, it's going to be really hard for somebody that makes toasters to infringe that claim because they're not making power sources. So it's something to keep in mind when you're drafting your claims is make sure you're drafting single actor claims. And I guess there's a couple of reasons for this. One, we don't know what the law is going to be. The Supreme Court may take this up, and we may say a reversal. The law is kind of in flux right now, so we don't exactly know what it's going to be. But second is it's much easier to prove infringement under a theory of direct infringement. You don't have to worry about proving intent. You don't have to worry about showing that they had knowledge of the patent. If you're going to sue somebody for patent infringement, you'd much rather do it under a theory of direct infringement rather than indirect infringement. Second tip is draft claims from the perspective of different participants in the method. And this really relates to if you're looking at computer interactive type methods. Think about who the participants are going to be and try to draft your claims from the perspective of each participant. An example I have is if you have an e-commerce type transaction where you have a user and a merchant and then let's say a bank, try to draft a claim that's from the perspective of just the merchant. So if you're the merchant's server, what is that merchant server going to do? Well, it's going to get a request from a user. Then it's going to provide information to the bank, and it's going to get information back. But you want to look at all the steps as all being steps that are performed by that merchant server. And maybe another claim that's all the steps from the perspective of the bank's server. And certainly you may want some claims that are drafted more broadly than that, but think about drafting some claims that can be infringed by a single actor. And finally, make use of apparatus and system claims. We talked today a lot about method claims, but include system claims as well, even if you're talking about computer software, even if you're talking about things that are largely methods, draft them in the form of a server that's going to perform these steps. Okay? That's all I had today. I hope you enjoyed the presentation and enjoy the rest of your day.